In this video, I'll introduce affirmative action in the context of employment. There has been a lot of debate of affirmative action in college admission. Here, I focus on affirmative action in employment, including hiring, promotion, and layoff. Before I introduce court cases on affirmative action in employment, let's first clarify the definition of affirmative action and how the policy of affirmative action has been developed and implemented. What is affirmative action exactly? Here is the definition provided by the U.S. Equal Employment Opportunity Commission. Affirmative action means those actions appropriate to overcome the effects of past or present practices, policies, or other barriers to equal employment opportunity. The roots of affirmative action can be traced back to the civil rights movement. In 1961, President John F. Kennedy signed Executive Order 10925. The executive order established the President's Commission on Equal Employment Opportunity, which was headed by then Vice President Lyndon B. Johnson. The executive order stated that contractors doing business with the government will take affirmative action to ensure that applicants are employed and employees are treated during their employment without regard to their race, creed, color, or national origin. The order did not advocate preferential treatment of affected groups, but aimed to eliminate discrimination. The legal status of affirmative action was solidified by the Civil Rights Act of 1964. This act has become one of the most significant legislative achievements in American history. The act prohibits discrimination based on race, color, religion, sex, national origin, and later sexual orientation and gender identity. The legislation had been proposed by President Kennedy in 1963, but it was opposed by filibuster in the Senate. After Kennedy was assassinated on November 22, 1963, President Johnson pushed the bill forward. Here is some background of Lyndon Johnson. He was a teacher at a segregated school for Mexican-American children south of San Antonio. After entering politics, Johnson served 6 terms in the House. He was then elected to the Senate in 1948. In 1953, he became the youngest minority leader in Senate history. He then became majority leader in the following year. In the 1960 campaign, Johnson, as Kennedy's running mate, was elected vice president. After Kennedy's assassination, Johnson was sworn in as president. Johnson made use of his rich experience in legislative politics, along with the Johnson treatment of a combination of flattery, threats, and persuasion in support of the bill. Title VII of the Civil Rights Act offered a similar understanding of affirmative action as Executive Order 10925. The Civil Rights Act of 1964 was not designed to grant preferential treatment to any group because of race, color, religion, sex, or national origin. The sponsors of the Civil Rights Act of 1964, Senators Joseph Clark and Clifford Case, emphasized the non-preferential interpretation of affirmative action. The act reads, "Nothing contained in this subchapter shall be interpreted to require any employer to grant preferential treatment to any individual or to any group because of the race, color, religion, sex, or national origin of such individual or group on account of an imbalance which may exist with respect to the total number or percentage of persons of any race, color, religion, sex, or national origin. The Civil Rights Act aimed to establish a conciliation process by which victims would be restored to the situation they would have had in the absence of discrimination. To carry out the conciliation process 1 year after the enactment of the Civil Rights Act of 1964, a new federal agency was established as a branch of the U.S. Department of Labor. This federal agency is called the Equal Employment Opportunity Commission. The commission requires employers to report various information about their employees, in particular their race and ethnic categories, to prevent discrimination based on race and ethnicity. Before moving on, it is important to clarify some terms. The first term that needs to be clarified is race. Title VII prohibits employer actions that discriminate by motivation or impact against persons because of race. But Title VII does not contain a definition of race, nor has the Equal Employment Opportunity Commission adopted one. For the collection of federal data on race and ethnicity, the Office of Management and Budget has provided 5 racial categories and 1 ethnicity category. The 5 racial categories include American Indian or Alaska Native, Asian, Black or African American, Native Hawaiian or other Pacific Islander, and white. The 1 ethnicity category is Hispanic or Latino. The second term that needs to be clarified is reverse race discrimination. Some people may say reverse race discrimination does not exist. Let's look at what the law says. Title VII prohibits race discrimination against all persons, including Caucasians. Some courts take the position that if a white person relies on circumstantial evidence to establish a reverse discrimination claim, he or she must meet a heightened standard of proof. For example, the Seventh Circuit held that white employee must show background circumstances demonstrating that particular employer has reason or inclination to discriminate invidiously against whites, or evidence that there is something fishy about facts at hand. But the Equal Employment Opportunity Commission applies the same standard of proof to all race discrimination claims, regardless of the victim's race or the type of evidence used. In either case, the ultimate burden of proof is on the plaintiff. In 1966, the U.S. Department of Labor began collecting employment records with breakdowns by race in order to evaluate hiring practices. In 1968, the Office of Federal Contract Compliance issued regulations which required for the first time that specific targets be set by which the effects of affirmative action programs could be evaluated. It was in these regulations and measures by the Equal Employment Opportunity Commission that the debate over affirmative action quotas had its origins. In 1971, in the Griggs versus Duke Power Company case, the U.S. Supreme Court unanimously ruled against Duke's requirement of high school diplomas or IQ tests for those applying for unskilled jobs. The decision held that Title VII forbids not only practices adopted with discriminatory motive, but also practices which, though adopted without discriminatory intent, have a discriminatory effect on minorities and women. The ruling provided a legal foundation for cases of disparate impact, asserting that employers may not use job requirements that adversely affect women and minorities unless required by what it termed business necessity. The Equal Employment Opportunity Commission was strengthened by the Equal Employment Opportunity Act of 1972, which enabled the Commission to file class action suits. Another significant Supreme Court ruling on affirmative action came in the 1978 case, Regents of University of California versus Buckey. Under the University of California at Davis admission policies, 16 of 100 places were set aside for minority applicants. Alan Buckey was a white applicant who was denied enrollment to the medical school even though his test scores were higher than the minority students who were admitted. The U.S. Supreme Court held that Buckey should be admitted to the medical school since the university policies constituted a rigid quota. But the university could continue to favor minorities in its admission practices because the policy had a compelling state interest to attain a diversified educational environment. After presenting a brief history of affirmative action, I now introduce a few cases of affirmative action in employment. In general, courts prohibit the use of affirmative action plans that provides a discriminatory preference rather than an equal opportunity. The first case is Perea versus Cincinnati Public Schools. A teacher at Cincinnati Public Schools challenged, among other things, the constitutionality of the school district's guidelines that required the district to try to maintain about the same racial balance for the teaching staff at each school within the district when making certain types of teacher placement decisions. The district court concluded that the school district's staff racial balancing guidelines were unconstitutional. The school district violated the teachers' equal protection rights if they surplus teachers on the basis of their race. The collective bargaining agreement between the school district and the Cincinnati Federation of Teachers included a provision on staff racial balancing. The provision called for the racial balancing of staff when teachers are surplused, that is, removed from their current position at a particular school based on decreased enrollment or a change in program offerings at that school. A human resources manager at Cincinnati Public Schools testified that the district's treasurer department provided the student-based budgeting guideline for HR and staffing. The budgeting guideline contained a paragraph called Staff Racial Balance that addressed racial composition of the staff at each school. The staff racial balance provision provides in relevant part as follows. It is important that the staff racial balance for each school be maintained as close as possible when considering surplusing. However, a school shall be in compliance with board policy if the school is within plus or minus 10% of the representative teacher workforce. The court declared that the racial balance provisions violated the Equal Protection Clause. The school district was prohibited from further racial balancing in making staff employment decisions. Affirmative action programs will be unconstitutional and violate Title VII if those programs provide racial preferences without a proven history of discrimination or are based only on underrepresentation. In the case Humphreys versus Pulaski County Special School District, Donna Humphreys was a white female who had been hired as an elementary school counselor by the school district. Humphrey had a doctorate degree in elementary education. She applied for virtually every elementary school assistant principal position that had been available in the district. In 2007, Humphreys also applied for a director of counseling services position with the district. In each instance, she asserted that the district preferentially hired black applicants. Humphreys filed a claim with the Equal Employment Opportunity Commission alleging that the district repeatedly denied her an assistant principal position based on her race. The Eighth Circuit concluded that evidence that an employer followed an affirmative action plan in taking a challenged adverse employment action may constitute direct evidence of unlawful discrimination. If the employer defends by asserting that it acted pursuant to a valid affirmative action plan, the question then becomes whether the affirmative action plan is valid under Title VII and the Equal Protection Clause. The court held that the teacher raised a genuine issue of material fact concerning whether there was a specific link between the district's decision not to promote her and the district's various affirmative action policies. Humphreys presented evidence that the district's interview committees were instructed to abide by the district's affirmative action policies. The district's published hiring goals include hiring at least one minority administrator at each school and attaining a ratio of black administrators in proportion to the number of black certified personnel in the district. The court stated that a reasonable jury could conclude that job interviewers who had been trained in the district's racial equality policies effectuated those policies through their scoring and ranking of applicants, and that the district therefore acted pursuant to its affirmative action policies when it failed to promote Humphreys to one of the assistant principal positions. An affirmative action plan preferring minority teachers over equally qualified non-minority teachers violated Title VII. The court further stated that an affirmative action policy is valid if the policy is remedial and narrowly tailored to meet the goal of remedying the effect of past discrimination. What policy is considered as remedial? A policy may be considered remedial if the employer has identified a manifest imbalance in the workforce. A policy may be shown to be remedial through evidence that it was implemented in adherence to a court order, whether entered by consent or after litigation. But a policy may not unnecessarily trammel the rights of non-minorities, and it must be intended to attain a balance, not to maintain one. In addition to affirmative action in hiring and promotion, efforts have been made to protect the diversity gained through court order and voluntary affirmative action by providing a preference in organization downsizing. When a reduction in school is necessary due to budget cut, declining enrollment, or a change in education priorities, it generally is based at least in part on tenure and seniority within teaching areas. School policies have been challenged if they consider race as a preference. In the Wygant case, the collective bargaining agreement between Jackson Board of Education and the teachers' union provided that if it became necessary to lay off teachers, those with the most seniority would be retained, except that at no time would there be a greater percentage of minority personnel laid off than the current percentage of minority personnel employed at the time of the layoff. The board implemented the policy. During certain school years, non-minority teachers were laid off while minority teachers with less seniority were retained. The U.S. Supreme Court, in a 5-4 decision, concluded that the layoff provision was based on race and therefore violated the Equal Protection Clause. In the context of affirmative action, racial classifications must be justified by a compelling state purpose, and the means chosen by the state to effectuate that purpose must be narrowly tailored. Justice Lewis Powell wrote, "Societal discrimination alone is insufficient to justify a racial classification. Rather, there must be convincing evidence of prior discrimination by the governmental unit involved before allowing limited use of racial classification to remedy such discrimination. The role model theory employed by the district court would allow the board to engage in discriminatory hiring and layoff practices long past the point required by any legitimate remedial purpose." The court also rejected the lower court's reliance on role model theory, which argued that racial preferences were permissible as an attempt to remedy societal discrimination by providing role models for minority students. The U.S. Supreme Court stated that because the role model theory does not necessarily bear a relationship to the harm caused by prior discriminatory hiring practices, it actually could be used to escape the obligation to remedy such practices by justifying the small percentage of black teachers by reference to the small percentage of black students. Carried to its logical extreme, the idea that black students are better off with black teachers could lead to the very system the court rejected in Brown versus Board of Education. Societal discrimination, without more, is too amorphous a basis for imposing a racially classified remedy. There are numerous explanations for a disparity between the percentage of minority students and the percentage of minority faculty, many of them completely unrelated to discrimination of any kind. In fact, there is no apparent connection between the two groups. Nevertheless, the district court combined irrelevant comparison between these two groups with an indisputable statement that there has been societal discrimination and upheld state action predicted upon racial classifications. No one doubts that there has been serious racial discrimination in this country, but as the basis for imposing discriminatory legal remedies that work against innocent people, societal discrimination is insufficient and overexpensive. In the absence of particularized findings, a court could uphold remedies that are ageless in their reach into the past and timeless in their ability to affect the future. Public schools, like other public employers, operate under two interrelated constitutional duties. They are under a clear command from this court, starting with Brown versus Board of Education, to eliminate every vestige of racial segregation and discrimination in the schools. Pursuant to that goal, race-conscious remedial action may be necessary. On the other hand, public employers, including public schools, also must act in accordance with a core purpose of the 14th Amendment, which is to do away with all governmentally imposed discriminations based on race. These related constitutional duties are not always harmonious. Reconciling them requires public employers to act with extraordinary care. In particular, a public employer like the board must ensure that Before it embarks on affirmative action program, it has convincing evidence that remedial action is warranted. That is, it must have sufficient evidence to justify the conclusion that there has been prior discrimination. We have recognized, however, that in order to remedy the effects of prior discrimination, it may be necessary to take race into account. As part of this nation's dedication to eradicating racial discrimination, innocent persons may be called upon to bear some of the burden of the remedy. When effectuating a limited and properly tailored remedy to cure the effects of prior discrimination, such a sharing of the burden by innocent parties is not impermissible. In a different case, the challenged statute required at least 10% of federal public works funds to be used in contracts with minority-owned business enterprises. This requirement was found to be within the remedial powers of Congress, in part because the actual burden shouldered by non-minority firms is relatively light. Layoffs impose the entire burden of achieving racial equality on particular individuals, often resulting in serious disruption of their lives. That burden is too intrusive. We therefore hold that as a means of accomplishing purposes that otherwise may be legitimate, the board's layoff plan is not sufficiently narrowly tailored. Other less intrusive means of accomplishing similar purposes, such as the adoption of hiring goals, are available. For these reasons, the board's selection of layoffs as the means to accomplish even a valid purpose cannot satisfy the demands of the Equal Protection Clause. Justice Thurgood Marshall dissented. He wrote, "I too believe that layoffs are unfair, but unfairness ought not to be confused with constitutional injury. Paying no heed to the true circumstances of the petitioner's plight, the plurality would nullify years of negotiation and compromise designed to solve serious educational problems in the public schools of Jackson, Michigan. Because I believe that a public employer, with the full agreement of its employees, should be permitted to preserve the benefits of a legitimate and constitutional affirmative action hiring plan even while reducing its workforce. I dissent." Justice John Paul Stevens also dissented. He wrote, "In my opinion, it is not necessary to find that the Board of Education has been guilty of racial discrimination in the past to support the conclusion that it has a legitimate interest in employing more Black teachers in the future. Rather than analyzing a case of this kind by asking whether minority teachers have some sort of special entitlement to jobs as a remedy for sins that were committed in the past, I believe that we should first ask whether the board's action advances the public interest in educating children for the future. If so, I believe we should consider whether that public interest and the manner in which it is pursued justifies any adverse effects on the disadvantaged group." In this video, I introduced affirmative action in the context of employment. I presented a brief history of affirmative action and court cases on affirmative action in employment. Affirmative action programs are unconstitutional and violate Title VII if those programs provide racial preferences without a proven history of discrimination or are based only on underrepresentation. The courts held that an affirmative action policy is valid if the policy is remedial and narrowly tailored to meet the goal of remedying the effects of past discrimination.